Thank you so much, and thank you for joining us for Insider Leases. Insider Leases. My name is David Levy from Keen Summit Capital Partners and Summit Investment Management. I'm your moderator. This webinar is part of the Financial Poise series, Ethical Issues in Real Estate-Based Bankruptcies. Slides 7 and 8 provide a summary of the series and episode. Speaking of the slides, you should understand from the get-go that we will not be stepping through the PowerPoint in order, nor will you have to listen to us read any slides. This webinar, like all Financial Poise webinars, is a conversation. Keep the PowerPoint presentation handy, however, because I will try to indicate what slides our conversation is touching on as we proceed, so you can take notes. Our panelists today are Samantha Rubin, an attorney from Denton's in Chicago and a member of the firm's restructuring, insolvency, and bankruptcy practice. Matthew Christensen, an attorney from Johnson, May, and Boise, Idaho. He's a member of the firm and practices bankruptcy, real estate, civil litigation, and other business matters. Jonathan Aberman is an attorney from Troutman Pepperlock in Chicago. John represents lenders, CMBS, special servicers, and various secured and unsecured creditors in complex loan and workout scenarios. Again, I'm David Levy from Keen Summit Capital Partners and Summit Investment Management. We provide real estate services like brokerage, auction, lease restructuring, and more for bankruptcy and other special situations. Our parent company, Summit Investment Management, buys all kinds of distressed debt and provides bridge and bankruptcy financing. We appreciate you're not spending your money and time to attend this webinar to hear infomercials about us. You can read more about us, though, on slides 55 through 58. This webinar is a production of Financial Poise. To receive our great weekly newsletter, go to financialpoise.com/subscribe. If you're attending the live premiere of this webinar, you can submit questions using your web portal. If you're watching this on demand and have any other questions after the webinar, you can send an email to info@financialpoise.com. Just include your question and the name of the webinar episode or episodes, and we will do our best to get back to you with an answer. Lastly, thank you to our sponsors of this episode, National Law Review, a premier legal news website, Sunburst Digital, makers of Type to Learn typing app for education, and Max Asset, a simpler, easier way and better way to conduct asset sales. Okay, as the legendary Jackie Gleason used to say, and away we go. So today, of course, we're going to have an important conversation about ethics, specifically ethical issues in real estate-based bankruptcies stemming from insider leases. Our esteemed panelists will speak from a variety of perspectives based on their professional background. As I mentioned, Samantha Rubin from Denton's works with debtors and creditors. Jonathan Aberman from Troutman Pepperlock in Chicago specializes in creditor and lender representation, and Matt Christensen from Johnson May covers a variety of practice areas inside and outside of bankruptcies. So let's start with the basics here. What are ethics? A good kickoff question for you. Matt, please give us your thoughts.
So this is just broadly ethics, not necessarily in the legal field. And I think there's multiple ways of looking at it, but I've always thought about it as, what action am I going to take when nobody's really watching what action I'm taking, right? Am I making the right choice because it's the right choice? And so it's applicable whether you're in a business situation, whether you're in a legal field, whether you're in finance, whether you're in whatever, but essentially, am I doing the right thing?
Thanks, Matt. John, what can you add?
Well, I would say for the non-lawyers on this call, I think they would be happy to know that there are a set of standards and an ethical code of conduct that attorneys adhere to. I know that I try to adhere to that, and I hope most lawyers do. I consider, the ethics, legal ethics, certainly to be the sort of rules of the road and the standards that not only do we adhere to, but we govern ourselves by in terms of acting fairly and reasonably, and how we interact with clients and how we interact with opposing counsel, how we interact with courts and other tribunals. And the interesting thing about lawyers is, we have to call our own fouls on ourselves too. So we all have to kind of be mindful of these rules and be sure that from a standpoint of making sure our profession is doing the right thing, making sure that we're all adhering to these rules.
Samantha, please give us your thoughts.
Thanks, David. And, to tie together sort of what Matt and Jonathan said, I think ethics can apply to both business persons, people, business folks and lawyers. Sometimes there's actual legal liability for, fraudulent transfers, usurpation of corporate opportunity, and unjust enrichment. But sometimes the situation may not be illegal, but just strike some people as questionable. And, in our world of financial distress, there's a lot of aggressive, participants on all sides of the equation. And these kinds of questions are frequently raised, especially when we get into bankruptcy. And, when there's an insider involved, as we'll talk about later, there may be fiduciary duties and other duties, which result in a higher level of scrutiny.
Well, I heard a couple references to non-lawyers, and I would be one of them in this group. And what I would add to this discussion was a very memorable presentation I saw some years ago from the Turnaround Management Association in Chicago, where they had Andrew Fastow, the former CFO of Enron, speak. And it was pretty remarkable because he held up a card and he said, "This is my prison ID." And he held up a plaque that he got from CFO magazine, where he was Chief Financial Officer of the Year. And he said, "I got the same two things for the same set of activities. And along the way, everything I did was approved by my board and approved by my attorneys and approved by my bankers. And not only that, they all said I was doing a great job. But I knew that the collective effect of all of these independently legal and ethical actions was a complete fraud, and therefore it was unethical, but also illegal." So we'll delve into it deeper. Next in line here is the question of what are legal ethics? And John, of course, the American Bar Association, known as the ABA, has provided the framework for ethical questions called the model rules. How do the model rules influence your practice?
Well, they permeate every aspect of our practice in terms of how we interact with clients and how we deal with situations, how we handle how we interact with judges, how we handle money. Again, these are sort of the rules of the road for fair practice. And so when you're dealing with complicated situations, these rules help you understand who are your clients, how to avoid conflicts of interest, how to make sure, how to advertise, how to deal with unrepresented people. Every aspect of behavior and practice as a lawyer needs to be mindful of these rules. Otherwise, you run into problems and you could be sanctioned or worse. So we are all very mindful. We all take a test when we're in law school to be sure that we understand these ethics, and we have to get training every couple of years on ethical issues. And so, yes, they're very important to what we do. And as I said, I think we all try our best to be as ethical as we can be in every situation.
Sure, makes sense. Samantha, please pick this one up. What do you think?
Yeah, I want to highlight three main ways that the model rules have impacted my restructuring practice. And the first one is sort of related to this presentation specifically, but the question is, who is my client? When you're representing a corporation, you may be representing the CEO, the directors, and so you sort of have to ask yourself, who is my client? Especially, in the context of our presentation here, where you have a landlord that's related to the operating tenant. Clearly identifying who the client is key for lawyers. Another basic tip is, one applicable to all bankruptcy lawyers, I would say, is staying up to date on the various changes to the bankruptcy rules and procedure, and also the local rules and specific procedures of each judge. For example, I recently learned that the Delaware local rules were updated in February 2025. So we're going through and updating our forms, which, the judges notice. So that's important. And then the third and last, thing from my experience is from a recent bankruptcy case where we serve as the debtors counsel to multiple healthcare facilities throughout the country. And when we first filed the case, at least I was getting near daily calls from various participants in the case, whether they're creditors or just claimants, and they sometimes want legal advice. And you have to be really clear about who you represent, that you don't represent them, but sort of point them in the right direction and, carefully tread which information you give to them.
Lastly, Matt, what do you think?
So I'll echo what everybody else said. I think one thing I would point out too is that the ABA has what they call model rules of professional conduct. Every individual jurisdiction has adopted some version of those rules, but there may be distinctions or differences between jurisdictions. So if I'm practicing in Idaho, but I also practice in California, or I also practice in Illinois, the version of the rules that's adopted in each location may be different. So what may be okay in one spot, you may be running into a rule issue in a different spot. So if you do have that multi-jurisdictional practice, just being aware of what the differences are is important.
It's great perspective and a great lead-in, because the model rules are a critical part of this presentation. An ethics presentation for the legal community revolves around the model rules. And there's quite a few, but today we're going to be highlighting a handful, including Rule 1.7, conflict of interest, current clients, Rule 1.8, conflict of interest, current clients continued for specific rules, Rule 3.3, candor towards the tribunal, and Rule 4.3, dealing with unrepresented person. Moving along here, Matt, it's important that we talk about insider leases. So please give us some insights onto the non-statutory insider test.
So I'll first just mention there is a statutory insider definition. The bankruptcy code has section 101. It's basically definitions of different terms used within the code. There is a definition of insider in that section. So obviously if you meet that definition, you're an insider. But it's not an extremely broad definition. So there are also some non-statutory insider tests that have been developed. And they basically stem from, okay, you've got a corporate debtor. Well, the parent company or the partners in that company or the shareholders, officers, directors might be a statutory insider. But is there someone who's got a close enough relationship with that debtor that it should also be considered an insider? So there's, I think one of the slides has the definitions of the different approaches, but closeness, control, similarity are the sort of terms that get kicked around. But if I have a close enough relationship with the debtor to suggest that whatever transaction happened wasn't really an arm's length transaction, or I have enough control over the debtor. Maybe it's a lender that's got a control agreement that's now in place where they're directing everything that the debtor can do. Maybe that lender's now morphed itself into a non-statutory insider. So the key is both in the context of today, we're looking at lease transactions, but there's other parts of the bankruptcy code, like when you're talking about avoidance claims, where the fact that you're an insider will make a big difference in the time frame that you're looking at of how far you can go back on those avoidance claims. So whether you're statutory or non-statutory, if you're on the creditor side, you want to stay as far away from that line as you can, or as close to the line, but without going over it as you can, depending on your approach.
Thanks, Matt. And John, how do leases play a role in a bankruptcy? What might each side's interest be?
Yeah, before I get to that, let me just add a quick point to what Matt said. I mean, the characterization of an insider is very important in bankruptcy, because insider transactions or transactions with an insider, leases with insiders, sales to insiders, claims of insiders are going to be much more heavily scrutinized by the bankruptcy court. And so knowing who those insiders are and what their interests may be is very important, especially as you get through a bankruptcy reorganization, to know how courts might actually be looking at these transactions. And there's a certain healthy skepticism and scrutiny, I think, that is usually directed towards insiders when you're dealing with bankruptcies. So leases play a critical role in a lot of real estate bankruptcies in particular. Leases are probably going to be the lifeblood of a real estate bankruptcy, the lifeblood of a property, its income source. And so having a revenue stream, having leases that are paying, that are not in default, that are at market rates or better, are going to be very important to a debtor if they're going to try to reorganize their real estate business. And so I think, you know, there's a particular attention paid to leases in these kinds of bankruptcies. Now, you know, the other situation though that we encounter a lot is sort of the flip side, where, and we saw this with a number of the retail wave of retail bankruptcies in COVID, et cetera, where you have a retail business that is a tenant, not necessarily a landlord, but a tenant in a number of different properties. And one of the key features of bankruptcy is the ability of a debtor who's a tenant in a number of different locations to be able to reject their leases, to shed onerous leases, above market leases, or underperforming stores, things of that nature. So you have this tension always going into these bankruptcies between landlords and tenants, especially when you're dealing with real estate bankruptcies, retail bankruptcies that rely on stores, things of that nature. And so having a full analysis of what various leases are doing for the debtor is a very, very important threshold gating issue in most of these cases.
Well, in picking that up, there's a reason why they call this line of work special situations, because we do encounter any number of scenarios, not the least of which is a restaurant, for example, might own the building but be running a restaurant out of it and then leasing it back to themselves. So we will sort through a number of different scenarios now as we get into a series of ethical situation case studies and also touch on some actual cases along with hypotheticals. So I will start with on the first one here, which brings us to slide 21. And this one pertains to INRE Scott Acquisition Corp. And I'll set it up here. Scotty's Inc. is the wholly owned subsidiary of Scott Acquisition Corp. Prior to their bankruptcy, Scotty's Inc. and Scotty Acquisition Corp., collectively the debtors, were retailers of building materials and home improvement products for the do-it-yourself home improvement market. The defendants were individual officers and directors of Scotty's Inc., known as Scotty's. The complaint alleges the defendants' misconduct as follows. In 1998, Scotty's entered into a loan and security agreement with Congress Financial Corporation. We'll call them Congress. Under that agreement, Congress loaned Scotty's certain sums of money and took a security interest in substantially all of the debtor's property. Scotty's, however, was unable to make the required loan payments. As a result, Scotty's and Congress made various amendments to the loan agreement. During negotiations relating to the loan, Congress expressed its desire to have Scotty's divest itself of real estate holdings and pay down the amount owed to Congress. This would not only reduce the amount to Congress, but would also allow inventory to be the sole focus of Congress's security interest. Having inventory as the only collateral would allow Congress with a quick exit strategy, payment on a potential Scotty's liquidation. As such, Scotty's began divesting itself of its real estate holdings on a sale-leaseback basis. Some properties were sold to independent third parties. Others, however, were sold to entities controlled by certain of the defendants. These insider defendants, through the controlled entities, paid less than fair market value for Scotty's choice real estate. In return, Scotty's received no more favorable treatment on the terms of the leases than it would have with third parties. Throughout, Scotty's failed to solicit and consider third-party officers for the purchase of its choice real estate. Further, Scotty's failed to seek any independent consideration or review of these insider sale and leaseback transactions. Accordingly, the complaint alleges that the defendants, the officers, and the directors of Scotty breached their fiduciary duty of care and loyalty in several respects. The complaint also alleges that the defendants had knowledge and rendered substantial assistance with regard to one another's breaches of fiduciary duties. Matt, given this fact pattern, what ethical issues do you see here?
I think this one highlights one of the things that Samantha brought up before, which is who actually is your client. If I'm the attorney representing Scotty's, what role did I play in the sale and leaseback transaction? What advice did I give to whoever the insider guy was that was arranging those leases with the insider companies? Did I make clear to them that, look, I represent the debtor company, the Scotty's, and I think we're just assuming here Scotty's Inc. or Scott Acquisitions is a bankruptcy debtor. So if I represented them in that transaction, did I make it clear to them, I don't represent the new landlord entity, and I think this is a horrible deal and you shouldn't be doing this? Did I voice that to anybody? I think from an insider perspective, all the problems you identified in those lease transactions, the statement itself explains what the problem is. Paid less than fair market value, but are charging fair market rent. So what's the trade-off? There wasn't any. So I think this is a good one to sort of emphasize who do I actually owe a duty to under the ethics rules, and it's going to be Scotty's. And what duty do I have to tell the guy I'm not representing the landlord entity? And if I was the one that drafted the sale and leaseback documents, did I put some provision in there for them to seek out and get independent counsel, and that sort of thing? So.
Thanks, Matt. John, what ethical issues do you see here?
Well, I largely agree with Matt. I mean, there's clearly insider issues. You have these insiders sort of on both sides of the transaction. They seem hopelessly conflicted. Are they self-dealing? If it were me in a bankruptcy and I represented the lender and I want the transaction to be blessed by the bankruptcy court and not undone for any reason, I would want there to be, I would want to be sure that, as Matt said, everybody has to have their own counsel. This has to be approved, scrutinized carefully. I mean, it seems here that the lender is trying to get paid off on its debt. I mean, that's fine. Lenders do have a lot of control in these bankruptcies because they have the collateral. They sit in the pole position. But that being said, I mean, there's a lot of best practices that even as a lender lawyer, I'd want to see. I mean, I've been involved in cases, and David, I think you have experience with it, is that, look, if you're trying to do a reorganization or a sale, and it's possible that someone in the ownership structure of the debtor is looking to be on the other side of the transaction, either as a purchaser or as a new landlord, or take over a lease, I wouldn't want that person to be in a position where they could self-deal. I would probably want to have an independent director in there, some third party fiduciary who could look over all of this and make sure that your insiders are not on both sides of the transaction, because otherwise you have these hopelessly conflicted situations. I've seen it a lot before, because with these closely held corporations, you're going to have principals who are the representative of the debtor, and they want to reorganize, but how do they reorganize? Well, they may be looking at how they cover their own issues. So that's kind of what jumps out at me.
Well, and a comment I would add to that is, so we're clear, being a business that owns a piece of real estate that you then lease back to the business is kind of a fundamental part of real estate 101. So the basic premise here is not problematic. It's everything that can stem from it and all these different issues that
totally agree. And everybody should have counsel.
Right.
Having one lawyer supervising all of these kinds of transactions is probably not a good idea.
Sure. Samantha, what can you add to this one?
Just one other point to add, because I think Matt and Jonathan did a good job, but I think the main point to emphasize is that the process matters too, how they conduct the negotiation of the leases and whether they market the property, which in this pattern, they did not market the properties to other third parties or consider any other offers. So there's also not real challenged value of, market value here for these leases. And I've seen a judge deny a sale of real property because there was no evidence of marketing of the property to others than the insider. So I think that evidence would be really important to a bankruptcy judge.
And Samantha, it's a great lead-in to a change in the fact pattern. What if the insiders had an unsolicited bid from a third party, but refused to negotiate with that third party?
It's another red flag, David. I think it would also depend at what amount this bid came in. You know, if it was so low that it was offensive and, you know, that would raise less of an eyebrow, for example. But if it met or even exceeded the amount of the lease, you know, that was, you know, transacted with these insiders, I think this is a bad look. And it could be a breach of fiduciary duties, you know, for failure to look out for the company's interest.
And Matt, anything to add to this change in fact pattern?
I agree with Samantha. I think it's it's an even worse red flag. I mean, the original transactions themselves sort of open that insider up to some claim against them in the bankruptcy case. If they actually had a third party bid that was better than the one they were negotiating on behalf of the debtor that they ignored, that's an even better claim against that insider that I'd be pursuing on behalf of the debtor. So I think it doesn't make the situation better. It makes it even worse.
John, what do you think?
Yeah, I agree with what's been said. You know, again, I think in bankruptcy, you know, disclosure, transparency, you know, yeah, these are the sort of hallmarks of bankruptcy transactions, and you're going to get scrutiny by the court. Sometimes courts aren't as on top of these types of issues, and it's incumbent upon the litigants to try to raise these issues and shed light on them. We have what's called a U.S. trustee in office in the bankruptcy case world, which is part of the Department of Justice that is there to scrutinize a lot of the transactions and things that happen in bankruptcy. Sometimes they're not as in tune to what's going on and need to be alerted. So, you know, again, a lot of these smaller cases, real estate related cases, you're going to have participants that are very closely involved in lots of the different aspects of the transaction. And, you know, as a lawyer, I think all of us on this panel are going to be very careful in terms of scrutinizing everybody's dealings with each other, and to make sure that we don't run afoul of not only our own ethical obligations, but whatever the obligations are under the bankruptcy code.
Well, let's throw another flag here. Let's spin the wheel again. Samantha, what if the insider had an unsolicited bid from a third party, but instead co-opted that third party to be an investor in the insider deal?
So I think this would still raise an eyebrow. The insiders are part of the deal. The deal is still a little bit tainted, and it sounds like they still don't have their own counsel. People still are represented by the same attorney, but I think it also depends whether the price is market. You know, perhaps the investor brings more money in to the table and, you know, brings the lease up to market. But again, back to what John was saying, I think disclosure. If, you know, you kind of get that feeling in your stomach when something is off, and I think you got to follow that.
And Matt, how does this fact pattern variation strike you?
I mean, the whole reason they were doing the sale and leaseback transactions were to make it easier to repay the loan that Congress had made, right? So if the insider's convincing this third party to come in and essentially be an investor, why aren't they convincing them to be an investor in the debtor, that those funds can then be used to repay Congress? Why are we setting up this whole extra layer of problem? So I agree with Samantha. I think it still is a pretty big red flag, and you know it doesn't solve the underlying insider lease problem, but opens up that insider to even more potential liability.
John, what do you think?
Yeah, I agree. You know, when Samantha was talking first, I was thinking you gave the fact pattern like collusion, right? Like you don't want to see an insider colluding with another party to try to steer you know, a reorganization in a certain way. That's a red flag. That's something that's going to get a lot more scrutiny. You know, so I think that's really the only thing I would add. I think Matt's right. You know, I think what this fact pattern really shows is all the ways that an insider really can create issues and problems and concerns. And again, just being really mindful of who the insiders are in a case and what their interests are and their motivations is really important as you get into these cases.
Yeah, well, it's a great case study, and we're going to have more. But as the real estate professional on here, what makes this interesting is that oftentimes a real estate based business, particularly in retail, has a build to suit aspect of it. The building was designed for a particular business in mind. And if things get distressed, a logical thing you would do as a first step would be a sale leaseback to generate the capital from the equity in the building. And there might be a specialized investor that would be interested in a property built for this specific purpose. And so somebody who knows the deal very well, like an insider, might want to step up and do that, but it certainly does create an array of issues that we've been discussing. As I mentioned, we're going to be talking a lot about the model rules today. And Matt, talk to us about how model rule 1.7, conflict of interest, current clients would apply to this case.
So rule 1.7 is sort of the basic conflict rule. There's some nuances to it, but basically, if you're representing one client, you can't represent the other party to the same transaction. Or if you're in a litigation, you can't represent one side of the plaintiff and also represent the defendant. It would seem like that's sort of a no-brainer, right? You can't represent the plaintiff and the defendant in the same case. I think when this becomes a little more difficult is with larger firms with multiple offices around the country. Maybe one person in a Chicago office is representing this party, and you've got somebody in an Atlanta office who's representing a different party. Now those two parties are doing some transaction together and they want their normal attorneys to represent them. That's when this sort of conflict of interest comes in. In the Scotty's situation, this goes back to the Scotty's entity is the bankruptcy attorney's client, the insider person and the insider landlord. You can't represent those parties at the same time. That's why we talk so much about making sure there's multiple attorneys involved and everybody's have a chance to have their own counsel. But it's the basic conflict rule that just says don't represent multiple parties in the same transaction.
Thanks, Matt. Let's turn our attention now to case study number 2, which is Edgewater Medical Center. Background of this case is Chapter 11 debtor in possession brought adversary proceedings against its landlord in their common principle to set aside alleged fraudulent transfer and to recover on breach of contract, breach of fiduciary duty, and other theories. The bankruptcy court, Judge Bruce W. Black, held that, number 1, no transfer of interest of the debtor in the property occurred of a kind potentially subject to avoidance upon expiration of the debtor's purchase option under the lease. 2, the debtor failed to show that it was insolvent and rendered insolvent by a challenged rent payments. Number 3, the landlord breached covenant of good faith and fair dealing. 4, debtor's chief executive officer breached his fiduciary duties in allegedly obtaining inflated appraisals of the leased property, and that the debtor had the option to purchase at its appraised value so as to ensure the debtor would not exercise this purchase option, and that the lessor, another corporation that the CEO controlled, would continue to collect allegedly exorbitant rent. Number 5, the debtor was entitled to specific performance of the option as well as return of rent. 6, punitive damages were warranted. And 7, doubts about whether the debtor was the prevailing party counseled against an attorney fee award. So Samantha, given this fact pattern, what ethical issues do you see here?
So just to start, I want to say I'm glad this case is in our presentation because it has quite remarkable facts and I think really hits home to the insider lease issues we want to convey to our listeners. I have a few points I want to make on ethics, and I also want to call out a few interesting facts about this case. As a little background, this is a Northern District of Illinois bankruptcy case, and the trial on this issue lasted 5 weeks, which is pretty long in the bankruptcy world. And near the end of the trial, the defendant CEO, who was, had dual roles in both of the entities here, he fired his lawyer and then left the country, which is never a good fact pattern. And then the judge, as the judge says in his opinion, his or her opinion, decided to rule on the merits despite not having, him having lawyers anymore. So the entity at issue here is a hospital, and it had adjacent properties that were owned by the insider CEO, who owned those adjacent properties 100%. And the hospital had an option to purchase these adjacent properties, but did not exercise that option because the CEO gave them 2 different appraisals that had inflated the value. But if they had exercised this option, they could have avoided future rent payments, and it really would have been in the best interest of the hospital to purchase them. So the judge found that this was a breach of the covenant of good faith and fair dealing and a breach of contract for the CEO, and he placed the burden of proof on the insider landlord for charging excess rent, and then also failing, basically telling them they shouldn't exercise the option. These 2 appraisals had inflated value, and eventually the judge awarded about $3 million in punitive damages, imposed a constructive trust, and about $2 million of compensatory damages. So really the CEO was not acting in the best interest of, he's a fiduciary to the hospital, and he acted against, that requirement.
Good analysis, man. Thank you. Matt, what do you think of this fact pattern?
The interesting part to me was in the it's on, I think, the slide that you have up there, the part 4, the inflated appraisals that he got. But the key for me is so as to ensure that the debtor wouldn't exercise the purchase option. So it would be interesting to see, what was the evidence that was presented that was his intention. I can see somebody getting an inflated appraisal and just, hey, this is what the appraiser gave me, right? And so that's what we're making the purchase option. But the fact that he got the inflated appraisal so that the option was illusory, that is the key problem, I think, for me in sort of pursuing him. That, yeah, it looks like you're doing this great thing, putting this option into place, but you're making it so difficult that it's never going to actually be exercised. And in fact, that's what happened.
John, what's your assessment here?
Yeah, I would largely agree. I would largely agree with everything's been pretty much said. I don't really have a whole lot to add. Again, this is a complicated case. Fraudulent conveyance litigation is complicated. It's brought all the time. It definitely happens in the context of leasing. Again, these are complicated questions about value and, reasonably equivalent value and things of that nature. And so I think that's one of the things that we, especially in real estate related cases, I guess the overarching point I would make is, I think Matt really covered a lot of the details, but like an overarching point I would make is, like, valuation is pretty key throughout all aspects of bankruptcy cases. Real estate valuation, or just valuation in general of the debtor's assets, can be critical at numerous points: when the petition is filed, whether a lender is entitled to an adequate protection of his interest in collateral, whether a landlord is receiving adequate protection of his lease interests, what is the value of a property or a leasehold interest that might be sold. So, and then, taking it from there, whether or not there was reasonably equivalent value given in various situations prior to the bankruptcy. I think being mindful of value and how value affects real estate related cases is very important.
Just to add something to what Jonathan said, the best way to find what value is, at least what I've always learned, is to test the market and see what real bidders are willing to pay for it. And when you have an insider offering a price, it's just it's not tested against the market, and they obviously, they have inside information about the property and the other flow of funds for the business. A little bit gray.
And so, Samantha, between my career background and the lesson that my grandfather taught me about the value of my baseball cards was only what someone was willing to actually pay me for it. I agree with what you said there. John, let's stay with you for a second. Let's change the fact pattern again. What if one of the lenders to the hospital was an investor in the CEO's other corporation, but no one advised the other lenders of that? What type of flag are you throwing there?
Yeah, I mean, that's just, again, I can't imagine. Well, look, it's possible for various lenders or affiliates of lenders to be invested or to have lent into all different aspects and parts of businesses. And it's, I get concerned in those situations about consideration and, lenders don't want to be in a position where they could be construed as having some kind of control, too much control over a process, right? Or having too many feelers inside. Lenders should, they should be, this is our deal, these are our loan documents, these are the rights and remedies we're allowed to enforce, and stick to that. If you have, one lender for one entity, I mean, look, it's common that, there's takeout financing. There's possible that one lender entity lent to the debtor, and there's a refinancing or a new borrower coming in, and that same lender or a related lender might finance the transaction or the exit or the new borrower. I mean, that happens all the time. But again, these have to be arm's length, above board, fully disclosed kinds of transactions. Otherwise, they raise, the specter of conflicts of interest and things like that.
Thanks, John. Samantha, how does this variation strike you?
I don't have a ton to add other than what Jonathan said. I think, this could be a bad fact for the lender, depending upon, how much evidence there would be of some sort of collusion. I think the lender hopefully would have the financials of both entities. Yeah, I think this could be bad, but it would be difficult to prove.
Thanks, Matt. Matt, anything to add here?
Not necessarily to that twist in the fact pattern. There was an additional point I wanted to make about the underlying facts, though, and this goes back to that sort of representation of the client issue. That the case was an adversary proceeding brought by the debtor, who's represented by the CEO, against the CEO, right? So the attorney for the debtor had to tell his client, we're suing you and your other company, and I'm sure that was an interesting conversation. And that's always one of the hard parts as a debtor in possession counsel. If you're looking back at avoidance claims, this was a fraudulent transfer claim that they pursued. Looking back at avoidance claims, that the insiders of the company owners are usually some of the biggest targets of those claims. And so having a clear conversation with them that, hey, look, not only do you need to get your own separate counsel for this thing, but it's probably best if I discuss these claims with someone else at the company rather than you, and create some sort of wall there for that too. But this case was a good one for sort of bringing out how often that actually comes up.
And Matt, if we do the final variation here, what if the insider sold the lease into a securitization and then pockets the proceeds for other businesses?
So I think that makes it even more complicated. I mean, here you're talking about a fraudulent transfer claim. I think the transfer that they were alleging was the either the purchase option or the lease itself. And so if that was further transferred to some sort of securitization product, then all of a sudden you've got another party that you've got to add as a defendant in that case. They got to get their own counsel. Maybe they have good we didn't have any knowledge of this kind of defenses. And then sort of going back to the valuation issue, the value that thing was sold into the securitization product, the proceeds that the insider pocketed, is that evidence of what the actual value of this lease was, right? If it was a fair market lease that wasn't at inflated prices, how much above market value did they get? Could you use that as evidence that it wasn't a fair market value lease? So it just adds a whole bunch of more complexity to it.
Sure. John, give us your take, particularly given your niche in commercial mortgage-backed security.
No, I agree. I think it's a chasing the money problem, right? It's a further layer of insulation, or that's maybe the wrong word, but trying to it's even more remote. And I think problematic. I agree with Matt. You'd have to add that, you'd probably have to sue that party as well. Again, you're still going to go after the insider for whatever proceeds it recovered that you think were, that it shouldn't have received. But yeah, it definitely makes it much more complicated in that scenario.
Thanks, John. Samantha, any final thoughts on this case study?
Not much other than maybe this insider needs to hire one of the lawyers attending this and listening to all the ethical issues going on here, because I think the judge would find this to be, sort of a badge of fraud.
Love the hustle. Samantha, we're here to talk about the model rule. So please speak to the audience about the applicability of model rule 1.8 conflict of interest current clients as it relates to this case study.
Yeah, so this is a model rule that I think people sometimes forget about, especially as they work closely with their clients over time and really get to know their businesses, and maybe even sometimes get involved in their business. So what this rule says is that it deals with business transactions between a lawyer and their client. As a lawyer works with their client, they build trust and a relationship with them, and sort of this creates a possibility of overreaching when the lawyer participates in the client's business itself. For example, if the lawyer loans the client money or participates in some sort of sale or investment transaction, and the goal is for the lawyer always to put the client's interest above the lawyer's interest, and this sort of can create a conflict when the lawyer is directly involved in the business. And so here, potentially, if the attorney for the CEO had also invested in the business, this could raise a flag, and I think it muddies the waters. You start to get a conflict between what the legal advice the lawyer should be providing to their client, which is to abide by their fiduciary duties, which just gets complicated when they're involved.
Sure. Okay, let's turn to our third case study. This one is INRI 148 South Emerson Partners, LLC. 4 business partners, Drew Dozier, Michael Meager, Michael Meyer, and Stephen Smith, formed a company to operate a restaurant called Emerson Associates, and a separate company to own and lease Emerson Associates to the property at which the restaurant was operated. This is Emerson Partners. Years later, Meager, Smith, and Meyer, holding a combined 75% interest of Emerson Partners, voted to evict Emerson Associates from the property, which Dozier opposed. Dozier presented a lease that he argued governed the landlord-tenant relationship between Emerson Partners and Emerson Associates. However, the lease was undated, and the signatories on behalf of Emerson Partners and Emerson Associates were not identified. Dozier provided no evidence that the lease was ever presented to Meager, Smith, or Meyer, or even any correspondence regarding the lease existed. Further, while Emerson Associates paid rent and real estate taxes and liability insurance for the property, as well as constructed $1 million in improvements to the property, Dozier could not provide any evidence that such payments were made pursuant to the lease, or that Emerson Partners knew it was accepting payments pursuant to a lease, and the terms of the lease did not match. The court thus determined that no valid lease existed between Emerson Partners and Emerson Associates. John, what are the ethical implications here of this insider lease arrangement?
Well, there's a couple things that jump out to me here, and I think one of them is sort of clear from the fact pattern. The other is sort of part of what was going on in litigation. But in the fact pattern here, you've got a number of partners coming together in an LLC, ostensibly being represented by one lawyer, who is representing the LLC, but not necessarily representing the individual members of the LLC in their own capacity. And so as they create their operating agreement or whatever it's going, whatever their business arrangement's going to be, clearly Dosher was at odds or became at odds, and he or counsel he should have hired didn't necessarily flag that as they go down the road, there might be these potential problems. And it looks like he got outnumbered, and I don't have the operating agreement, but here it's probably the situation where 3 out of 4 vote for something, you've got a problem. So I think there's an issue here with number one, represent who the lawyer for the LLC was representing, and whether or not each of these parties should have had their own counsel, and whether the lawyer representing the LLC followed model rule 4.3 about dealing with unrepresented people, and whether or not each of them should have gotten their own counsel, okay, because to observe their own interests. Aside from that, you have the lease issue, where again, you clearly have a problem where this lease, or if you can call it a lease, was sort of operating in practice but never properly documented. And so these different legal entities appears that the different legal entities, the 2 different LLCs, didn't have each of their own counsel, putting aside the fact that the members may have been different. And, when you're dealing with these kinds of transactions that are in this, you have a lawyer here that seems to be doing it all at once, and you have one side of the transaction that wasn't being careful enough to figure out what was going on with the other. And as this went into litigation, I mean, yes, we have these decisions about whether there was really a lease here. That seems somewhat obvious. I mean, yes, maybe there was money that was exchanging hands and everything else. Did it really create a leasehold? I mean, that's one part of it. But the litigation in New York was also Dosher was trying to get the lawyer disqualified from representing the LLC. You guys said, wait a minute, how can you be taking this action on behalf of that when weren't you my lawyer? No, that's what the court said. No, you should have had your own counsel, and I'm not disqualifying the lawyer from representing. So those are the sort of issues that pop out in this. And, again, a lot of these, you're talking about a lot of real estate companies are using this LLC model. You have partners coming together with different levels of capital, different equity infusions, different rights. Do they owe fiduciary duties to each other or not? What does the operating agreement say? And there's, classic business divorce, right? Well, what happens when things go sideways? What happens when 2 people out of the 3 want one thing to happen and the other doesn't, or when there's a capital call, et cetera, et cetera. So all the more reason that, again, if you're a client, you have to be sure that you're getting counsel at all these levels, or at least running it through. As a lawyer, you better be mindful that if you're taking on this transaction, that you're following model rule 4.3, that where necessary, you need to advise the additional members of if their interests might somehow run in conflict with the interests of the LLC as a whole, you probably should be telling them or giving them the advice. The only advice you should be giving them is you need to seek the advice of your own counsel.
Thanks, John. Samantha, please give us your thoughts.
I agree with what John said. I think that's really good advice. I would just add that, 2 quick points. First, it's really important to document everything. So they may have had this lease, maybe that, draft lease agreement was what they were operating under, but it wasn't signed. So just be vigilant about documenting everything. And second, the court will appreciate having everything in stone. And I think that was part of the problem, is the judge said, look, we've got this unsigned agreement. What do you want me to do with this? So here there just wasn't enough. And at the end of the day, the court's the fact finder. And also it was 3 versus 1. So I think that tipped in the three's favor.
Sure. Matt, anything else to add here?
Just two things. The 3 versus 1 that Samantha just talked about, that's where you got to look at the operating agreement for the company. Do those guys with 75% interest even have the ability to vote to evict the tenant under the operating agreement? Maybe they don't. Maybe there's not an operating agreement. If there's no lease, there's probably not an operating agreement either. The other interesting point to me is that all 4 of them were members of both companies. And so you've got the landlord company and the restaurant company that all four of them are still part of. So is there some weird fiduciary duty issue between those three that wanted to evict the restaurant company? Well, what duties do they have to the restaurant company to fight that eviction? And so and maybe they're not 25% partners in the restaurant company, but they're just little minority holders there because they saw the value in the real estate and that's why they wanted the bigger piece there. I don't know. But those are just some interesting facts that may lead to more insider issues if you dig deep into it.
Thanks, Matt. Well, let's change the fact pattern here. John, what if there was an email confirming the terms of the draft lease, which the lawyer had in his inbox?
You know, that's maybe a better fact for Dosher, but I don't think it probably doesn't overcome the critical issue here. And, you know, clearly the lawyer may have missed something or whatever. But again, if this 25% minority person is, you know, maybe he has some kind of claim for malpractice against the lawyer. But you know, the lawyer might say it was a draft lease. It was never reduced to writing, and I'm doing what I was directed to do by my client, which is the you know, the owner of the property LLC, not the landlord LLC or the tenant LLC. So again, I think, you know, it probably doesn't solve the writing issue. It makes the lawyer maybe look bad. You know, again, if you dig deeper into this, you change the facts and you make the lawyer more and more incompetent, doesn't follow the ethical rules, whatever. Yeah, maybe there's some action that some of these people could take, but I don't think it overcomes the sort of key problem that Dosher has, and I also think it continues to highlight the main issue of, you know, in these transactions, you've got to make sure, as Samantha said, things have to be very well documented. As Matt said, you have to be sure that you understand what your operating agreement is telling you and what your rights are and where your interests lie, and making sure that there is proper documentation and counsel at all these levels.
And Matt, how does this change in fact pattern change your perspective?
Not in any way different than for Jonathan. I mean, it's potentially a good fact, but it's still just an email chain. And so, I mean, if every single party was on the email and every single party had chimed in saying, yes, I agree, those are the terms, then maybe you've got some argument. But, you know, even then you may run into an evidentiary statute of frauds type argument that, hey, that email chain doesn't constitute a writing for purposes of the lease, but it's still emails, so maybe it is writing. So it's a potentially better fact, but nothing more than that, I don't think.
Sure. Samantha, anything to add to this point?
Only thing I would add is that, you know, the court still found that the parties did not ratify the lease agreement through their behavior. So sometimes when parties don't sign an agreement or don't have an agreement, they can ratify the agreement through their behavior, through, you know, accepting money for lease payment, things like that. And so the court still found there was no ratification. So I think, like John and Matt said, this is a more helpful fact, but I think the court would still come out the same way.
And Samantha, from your perspective, how does it change things if a lawyer in the deal had a copy of the draft lease signed by one, but not both sides?
You know, I had to think about this one and do a little bit of research because I think that it depends on the state that you're in. I think in some states, they will say one side signing the agreement is satisfactory, and it probably depends on other circumstances. You know, let's say my client signed the agreement, but then the other side emailed us back and said, looks great, but they didn't sign it. You know, maybe a court would say that's enough, but I'm sure there are some states that say one party signature is not sufficient.
John, what do you think? I think you literally raised an eyebrow on this one.
Yeah, no, I think she's right. I mean, again, this gets back to like all of our law school training. Like, was there real, you know, was there a meeting of the minds? And, you know, is it, you know, can you infer this, or do you have to stick with the four corners of the document, all this kind of stuff? And, you know, again, it's a cautionary tale, right? I mean, this is just sort of in that vein. And, if it were me, I would be very uncomfortable, paying that kind of money, practically speaking, putting that kind of money in and trusting my partners if I didn't have a document, right? If I didn't have the actual writing. And again, I mean, one might feel sympathetic for Dosher because maybe he didn't get good legal advice. Yeah, I guess, maybe that's bad on him, but it's also maybe bad on the lawyer who, if you really do change this fact pattern, the lawyer had a copy and didn't follow through. Yeah, there's some blame to be placed on the lawyer, whether it's unethical, whether it's malpractice. I think that's a whole nother kettle of fish.
Or Matt, anything to add?
No, I think it doesn't get him far enough down the road.
And Samantha, as our final topic for today, please speak to the applicability of Model Rule 4.3 dealing with unrepresented persons to this case study.
Yes, so this model rule deals with discussions with an unrepresented person. You have to be, as I kind of foreshadowed at the beginning of our discussion, you have to be very careful when you represent a client and you're talking about the case or the issue with someone who is not your client or who is adverse to your client. And I mean, this happens all the time, I think, and you just have to be very careful to not imply to the other person that you're their lawyer. And if they think that you're their lawyer and they tell you that, you have to, make a reasonable effort to tell them that you are not. And so here it sounds like one of the hypothetical situations is that the owners had a lawyer together, but the lawyer really represented the business and not them individually. So that lawyer needs to be really careful when dealing with, that this one out person and the person who didn't agree, to make sure they don't think they're their lawyer. And I just want to add one thing before we sign off, and that the common theme here, I think, is that insiders are, kind of cast as the bad guys when you get into difficult situations like bankruptcy or insolvency. And so I think it's really important to document everything and document fairness to the transaction.
Absolutely. Well, this has been a great discussion into the audience. There is another case study. Our panelists had so much enriching content. We weren't able to get to it today, but you will find in Read Personal Touch Holdings. Additionally, you'll find in the presentation the actual text of the various model rules that we were discussing today so that you can review those. And with that, this concludes our webinar. Thank you for joining another entertaining yet educational production of Financial Poise. Look for Financial Poise webinars wherever better continuing education webinars are sold. And you can also look for the third and final episode of this series pertaining to single asset real estate cases coming up on March 20th. Thanks, everyone. Really appreciate your assistance, and thank you to the audience.
Thanks, David.
Thank you, David. Thank you, everybody.